Good morning, good afternoon, good evening, everyone. Thank you so much for joining me wherever you're joining me from, whichever time zone. And welcome to Immigration and Jobs Talk Show. I'm Nipasa Pradhan. I'll be your host for you today for an hour from now. And I have a very important disclaimer before we move on with today's topic of discussion and our whole webinar. So, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, dearest friends, welcome back to Immigration and Jobs Talk Show. And today we are streaming live right now on YouTube, LinkedIn, Facebook, and Twitter. Very happy to have you all join us. And remember that this is also going to be a very participative webinar. So, whatever thoughts you have, or comments you have, questions maybe, you are free to definitely ask your questions in the comments. We'll be very happy to answer them because we'll also have our expert, our guest for today, who's going to join us, and definitely he's going to make this session a very interesting one. So stay with us, all right? None other than attorney Chand Parvathaneni, managing attorney at the law firm of Sim Parvathaneni and Brown, based in Dallas, Texas, with extensive expertise in immigration law. Attorney Chand Parvathaneni is here to share his expertise on a crucial topic for many international students and professionals. And so you can see today's topic is here on screen. But without further ado, please help me welcome back Chand. How are you doing, Chand? Thank you so much for joining us today as well. And we're very happy to have you back.
Hello, Nipasa. Thank you for inviting me, and yeah, hopefully we'll have a very productive discussion today, and then we'll take up audience questions, and then see what are the new changes in H-1Bs and compliance issues, and everything surrounding immigration.
For sure, for sure. We are definitely going to do that. But before we move into the topic, friends, we also have what is happening recently. Chand, we were talking just before we started this discussion. So, in light of the recent news involving the arrest of Indian students in a major prostitution racket in Denton, Texas, what are the potential immigration consequences for those individuals who are facing charges such as solicitation of prostitution and even and evading arrest? Could you provide insight into how such legal issues might impact their visa status or future immigration prospects as well? Because since we are always
Yeah.
talking about immigration, could you please shed some light into this very recent case as well, and also maybe give out some tips to immigrants out there how to be careful?
Sure. And I think so. A lot of students they are coming here to study, and one of the requirements is they go to school and they follow the law 100%. I mean, there is no lenience, there is no leeway, and majority of the people do it. But unfortunately, once in a while, we do see the students they get involved. They have brushes with the law, and they get in trouble. And so lately, I mean, in the last 1 year, 2 years, I have seen an uptick in RFEs. Somebody applies for their OPT, STEM OPT, or they apply from F-1 to H-1, and then we see an RFE saying you have been arrested in the past because of this so and so reasons. So the bottom line is any kind of an arrest could cause a major impact to your immigration process, even if it's a small arrest. And so, from that viewpoint, I think what has happened in the last 2 days in the news that has come out is there were a bunch of people arrested in Texas, in Denton County, and this is for solicitation of people for sexual work. So it is
Right.
not. I mean, these students they were not really doing any human trafficking. They were not involved in any sex racket. They were not really like
Okay.
doing all those things. All they did is solicit a prostitute. So basically, what they did is they solicited somebody and thought they can get some sexual work out of them. Even solicitation is a crime. It doesn't have to be uh, human trafficking. It does not have to be sex racketing, all those kinds of stuff. In Texas, what has happened is until 2021,
Mhm.
if somebody goes and tries to meet up with a prostitute, just a solicitation, it used to be a misdemeanor B. So it was not really a felony. It used to be a misdemeanor. And what that meant is Solicitation, which is not the actual prostitution, but just going and asking somebody for some sexual favors for money, money is involved. It was not that big of a crime. But starting 2021, there was a new law passed in Texas, and this is specific to Texas. So even
Okay.
something simple like solicitation is considered a huge crime. It's actually a felony now. And when we talk about felonies, felonies have a huge immigration impact. If somebody has a felony on the record, they
Hmm.
probably will not be able to get through anything with immigration. They will not get probably get green cards. They might not get visas. Misdemeanors, one-time misdemeanor, if it's a small crime, depending on the crime, maybe. But if it's a felony, it's always a given that they probably will never have an approval from USCIS. They probably will not get visas, and so on. And what that means for all of us, normally, why do people get arrested? If somebody gets drunk and drives, the police catches them, it's an immediate arrest. So DUI is a
Yes.
very serious offense. They get arrested. If somebody goes to Walmart and steals something, maybe even something as cheap as $5, it's an immediate arrest. And we had
Hmm.
this happen. And I personally dealt with a lot of cases in Denton County where people got arrested stealing in Walmart. People got arrested for DUI. And just
Okay.
like a month back, I had a case where the wife called the cops and said the husband physically abused her. And and she just called the cops, and she was actually stating that she was not physically abused, but she was in a fear that her husband might abuse her. Even
Okay.
for that, the husband got arrested. So anytime you have an arrest. And then I also had a case in Denton County where this boyfriend girlfriend, they ran into an argument, and somebody saw this argument. They called the cops. The cops came and arrested this person because according to the eyewitness, there was some altercation and probably even some physical abuse happening. So
Hmm.
we are seeing more and more cases where people are getting arrested, and any arrest will flag up. I mean, so all these cases that I've been talking about, where somebody got arrested, we immediately in a month we saw Department of State contact these people and say your visa got cancelled. So even a small arrest for something like a DUI, something like a husband and a wife fight where it rose to the level of physical abuse, which is like a big no-no. You can't abuse your spouse. So so anytime there is an arrest, your visa more than likely will get cancelled. And not only that, depending on the nature of the crime, you might not even be eligible for getting a future visa. So the bottom line is any arrest is bad. And out of all these arrests, if something is a misdemeanor, maybe you will have a chance to argue. But if it is a felony, for sure, your immigration is going to be jeopardized. And the message for all is be cautious. Do not get involved with anything that is illegal. And again, if you have any arrest, 99% of the time, you will see that raised in an RFE in your future filings. Okay. So just
Okay.
be aware. And a lot of people got arrested, and it was a whole bunch of people. I was actually surprised because we do know that in Dallas County, in Denton County, in Texas, these kind of
Hmm.
raids are happening all the time. So I do see people get arrested, but I've never seen so many. I mean, out of the people that the information that they released, I mean,
Hmm.
almost majority were Indians and Indian students. So it is kind of surprising. And what that means is this is a lesson for everybody who's complying with the laws. It's a message that you have to be more cautious. Don't think anything is a simple crime. Crime is a crime. It'll impact your immigration process. So always follow the law.
Yes. Very well put. Thank you so much, Chand. And definitely, friends, I hope you noted that down. And also, Chand, if you could maybe just give us the real difference between a felony and a misdemeanor, so that folks out there could also be more clear about it.
Sure. And so the way the criminal law works in United States is it's a state law. So the
Mhm.
criminal law that we have in Texas, it is probably different from what they have in New Jersey. Every crime
Yes.
will have like a penalty, whether it's a jail time or whether it is a monetary penalty and so on. And
Mhm.
every state has different laws. For example, in Texas, solicitation of prostitution is a felony, and what that means is you can be put in jail for as long as 2 years. You can be penalized $10,000. That is pretty much what is the current statute in Texas. For the same
Mhm.
crime in New Jersey, for example, the penalties are different. For example, consuming marijuana, weed in California is completely legal. You cannot be arrested for that, whereas in
Yes.
Texas it is illegal. So the state law is pretty important. And from an immigration standpoint, people definitely have to understand what is a misdemeanor and what's a felony. A felony, so normally in Texas, the lowest crime is a misdemeanor C, then it is misdemeanor B, then it is misdemeanor A, then it becomes felony. And the highest class of felony is capital murder, where in Texas you can get a death sentence, a death penalty. So, from
Okay.
an immigration standpoint, any crime that has a jail sentence of more than 1 year is typically a crime where you more than likely will have a problem with immigration. And felonies are typically crimes that typically more than likely will have a jail sentence of more than 1 year. But again, misdemeanors are the lower level crimes. The felonies are higher level crimes, and even in felonies, normally we have a distinction. The highest felony, and then the highest felony in Texas is basically 99 years of jail sentence or death penalty if it's a murder case. So
Hmm.
anytime you hear the word felony, it typically means it's a crime that is like a little bit severe, something like assault, where there is violence involved, or something bigger. If you just go and steal something in Walmart for $5, it's still a crime, but it is not a felony. But if it is something like where you go and beat somebody and that person is like almost battling for his life, more than likely a felony, more than likely a high degree of felony.
Yes. Thank you so much for making that clear for us in such simple language, Chand. And I'm sure folks out there, this was beneficial. And thank you for, making it clear like we should really stay away from all sorts of fraudulent activities, harmful, I mean, things which are not ethical for that matter. So let's definitely stay safe with that. And thank you so much, Chant, for shedding some light on this recent case that is going on. So, folks, at this moment, I'll also want to say that please don't forget to subscribe to our channel, Immigration and Jobs Talk Show, to get to know more about this case because we'll definitely be covering as it unfolds. All right. So, uh, well, by the way, does that fall under a category of attempt to murder?
Yeah. So anytime you have attempt to murder, or even sometimes people solicit somebody to murder somebody else, criminal solicitation for murder. So these are typically always felony crimes because murder is like the highest crime. And
Mhm.
whenever you have murder and attempt to murder or solicitation to murder somebody, they always are felonies and they're highest level of crimes. And the police typically they give very high priority to those kind of crimes, to solve those crimes, to put people
Yes.
behind the bars.
Yes.
So anytime you hear the word murder, attempt to murder, sometimes it is even manslaughter. So manslaughter is lower than murder, but still it is like somebody is dying. So these are all typically felony crimes. And what exactly the kind of a jail sentence you can get for that kind of a felony? It completely changes from one state to another state in US, because criminal
Okay.
law is typically under the state law.
State
You'll
laws.
so you might see some minor variations. Like in Texas, death penalty is valid. In some other states,
Mhm.
death penalty is probably not legal.
Mhm. Right.
And in Texas, typically, if it is a capital murder, they give death sentence. Anything that is not capital murder typically will not go to that level, and it's probably a high jail sentence.
Right, right. And what about a sorry, solication? Also fall under category of attempt to murder case?
Solicitation. Yeah,
Solicitation,
I
yes.
mean, solicitation. Solicitation is like going and approaching somebody uh, to basically say, "Hey, will you go and murder somebody if I give you some money?" That is solicitation. So basically, you are
Okay.
soliciting somebody. You are approaching somebody with an intent to do something criminal. So
Mm-hmm.
solicitation, like what happened in Denton in the last 2 days, was solicitation for prostitution. So they were approaching somebody for the crime of prostitution. So you can see
Yes.
the same kind of solicitation for murder, where somebody goes and approaches somebody and says, "Hey, I'm going to pay you some money to murder somebody." That is a different kind of solicitation.
Mm-hmm. Okay, okay. Thank you so much, Chan, for making this very much clear. And at this moment, I'll just like to say hi to our folks out there who are commenting. Thank you so much for your questions and comments. We are definitely going to get to each one of these questions of yours. But quickly, Abio Dun is saying hello, everyone. So hello to you too. And Deepika Rao, thank you so much for joining. Akbar, we also have Vishnu Vardhan. Thank you so much for joining us. We will take up your questions. Just stay with us for now. All right. So, without further ado, let's get to our topic for today. The topic is what are the challenges in transitioning from F1 to H-1B. So we will definitely uh, talk about the challenges we face and how maybe what solutions we have today. And Chand, thank you so much for joining us for this topic. Maybe we can tell the friends out there what can they expect from us in this under this topic today in today's episode.
Sure. So I think the biggest challenge is make sure you're following the rules, and that is the biggest
Mhm.
challenge. So that means no crimes while you're on F1. No, not. I mean, I would say like try not even get a speeding ticket. That's how
Okay.
good your record should be. That being said, always, I mean, there are some things that are probably not in your hand, like speeding. Sometimes accidental speeding once in your lifetime. But overall, I mean, the big challenges you see are making sure you're maintaining your status, making sure you're doing what you're supposed to do, and then everybody's goal is once you graduate, your career. You're studying so hard, you're getting a degree, an
Mhm.
American degree, to have a good career. So I think the biggest thing, the biggest challenge is finding the right career, the right occupation, the right company to work with that aligns with your goals. So overall, what we will discuss is the legal aspects that you should keep in mind to make sure you have a seamless transition from F1 to a H1B, because your goal is end of the day you want to have a good career, you want to follow the rules, and do something good in your life that will also benefit the society, where you can use your education to benefit both your family and also the society. So we will talk about all the legal challenges that you might see, and the precautions that you are supposed to take to make sure that you don't see any kind of things that you cannot avoid. Things like bad RFEs, where they will say you did something bad, you did not work during your OPT, uh, or something of that sort. So we will talk about all the legal aspects that revolve around moving from F1 to H1B.
Definitely, we will. So it's a very critical process, for many individuals, especially those who are navigating their career paths, in the United States. So understanding the hurdles and, it can really make a big difference. So today, Chand is here to help us with that. And so I got this first question for you, Chand, right now that's coming up. Maybe before we get really deep into the topic, you can just give us the base, just in simple words, to folks out there, what is an F1 visa and what is an H-1B visa?
So both the visas, they are non-immigrant visas. So non-immigrant visas mean you have a temporary purpose. So you go, you finish up your job, and I mean finish up your what you're supposed to do under the terms of that visa, and then you're done. So that's a non-immigrant visa. It's not a permanent visa. It is given for a duration. And when we talk about an F1 visa, the F1 visa in simplest terms is it's a visa given to international students, and their only intention is to study full time, and they want to study full time in either a university, a college, or a school, and they're living in United States. They are going to one of these educational institutions and they're studying. That's all it means. So F1 is for international people, but who want to be students and study in US. So that is what is an F1 visa. H-1B visa, again, it's a non-immigrant visa, but it is a visa for those people who want to come to US and work. And these
Mhm.
people want to work in highly specialized fields like technology, engineering, or medicine. It is not any kind of work. It is a specialized work, and a specialized field where you at least have a bachelor's degree. So that is what is an H-1B visa, a work visa in a highly specialized field. And normally you get this H-1B visa for 3 years max each time. So each time you are eligible, you typically get it for 3 years. And there is a duration, which is why it is called a non-immigrant visa, because it is not a permanent visa.
All right. Thank you so much, Chand, for getting our ground ready for today's topic. All right, so moving on, I have this next question, and if you could provide a complete timeline, outlining the process from F1 visa to an H-1B visa, including any challenges faced, such as STEM OPT denial or an H-1B transfer also.
Sure. So, in terms of the timeline from F1 visa to OPT and to an H1, so I mean, it's a process that is spread out over a couple of years. So the study program. So people are typically doing either their bachelor's or their master's, or some people do their PhD. So people have to account for the time period that they're doing their studies. And once their studies are over, typically what happens is there is this like very nice feature in United States called optional practical training. So most of the students, what they do is they transition to this OPT, this uh, thing where they are still technically under student status, F-1 visa, but they're not students. They're actually working in the industry. So that is what typically people are supposed to do. They are supposed to finish their studies and then they're supposed to get this practical training. So practical training is where they can just get some training done, where they shadow somebody at the company and get some training done, or they can actually work, earn money, and learn in their course of study. So that is what somebody is supposed to do. Basically, they're supposed to utilize their OPT program and get some training done. And what that means for everybody is you have to start really planning early for your OPT. And there are strict guidelines. So you actually have to physically apply. It is not automatic. You have to apply. You have to go to USCIS, make a 765 application, pay the fees, and there is a process for that. You have to work with your school DSO, get the I-20, and apply a bit, before the deadline, and get your OPT. So get your OPT, and there are strict rules on what you're supposed to do. You're supposed to make sure you're at least getting training for 20 hours or more. You do that part, and once you're doing that part, uh, finish your OPT and look for good career options, because what happens is as you get your training, as you increase your skills, the industry skills, you will get more and more good offers. So look for companies that are legitimate, look for companies that are in your line, and try to get a job offer from them. And while you're doing that, you secure H-1B sponsorship, because what needs to happen is your OPT is limited. So you get OPT for 1 year, and if you're lucky and in the STEM field, you get 2 more years. So if you're in STEM field, you get 3 years of OPT. And once you're done with that, you eventually have to find a H-1B sponsor. So your goal during the OPT and STEM OPT is to find the right employer, because you'll find a lot of employers out there, and some employers are probably even shady. There are a lot of these consulting companies who are small companies, sometimes probably even large companies who are not probably following the rules. So always during your OPT, you have enough time. Research your companies, target your employers. Don't just randomly take any H-1B sponsorship, because we had cases where people just randomly went to this any employer, and these employers did multiple filings, multiple registration issues, and a lot of students, they were impacted. So target your employers, do a lot of research, and make sure the people you're working with, the employers who are giving you the job offer and saying that they're going to sponsor your H-1B, they are legitimate people, they're legitimate companies. You have enough time, there is no hurry. So take your time, do that research, and then make sure the company applies for your H-1B. Okay, so that is basically the final thing that you're supposed to do. Ensure that you get your OPT properly done, your STEM OPT properly done, and don't get a denial for your OPT or STEM OPT. And eventually have the company sponsor your H-1. And if the company is legitimate, more than likely your case will get approved. Because most of the time, what happens is if you're on F-1, you are getting a solid US education. And when the US CIS officers, they see that you graduated, you got all this education done in US, they are inclined to approve your case unless the company is bad or company is shady. So your bottom line is you already have that US education. Make sure you work with a legitimate company, and then majority of the time the case will get approved if the company is legitimate.
All right. Thank you so much. And also, since I feel like it is kind of timely, let's take up this question quickly from Facebook, from KP Karupu, asking what about the difference between CPT and OPT?
So OPT is optional practical training. So the word OPT means you typically finished your degree program, you graduated, and then after graduation, you're going and getting this practical training. So practical training basically means you're going out in the industry and you're working. You're working in the industry, and most of the time you're getting paid. So that is, so OPT is basically limited to those times where you graduated and getting this training, this work authorization after your graduation. CPT, on the other hand, again, it is practical training. It is actually you're working in the industry, you're probably getting paid. The only difference is it is curriculum practical training. So you probably have not graduated yet, you're still studying, you're still attending classes full time, and while you're attending classes, you're going off campus and working in the field of your study. So CPT means you are still a student attending classes full time. You have to attend classes full time, and then you're working and making money. OPT means you finished your graduation, you're not attending classes, all you're doing is only working. So that is the difference. One is where you're still attending classes full time, the other is where
Mhm.
you finished your graduation.
All right. Thank you so much. And KP, thank you for your question. I hope that is very much clear. All right, moving on now. Chand, I have this next question for you, and that is, what are the top five tips for successfully transitioning from an F1 student visa to OPT and ultimately to an H-1B visa?
Sure. I think the main thing is again applying for OPT, graduating at the right time because you do have to graduate. You do have to graduate with good GPA because GPA is sometimes a lot of good companies actually look at your GPA. So your first and foremost thing should be make sure you graduate well. You don't have any academic probations. You don't have any low grades. That is very important. Make sure you're taking right coursework because a lot of schools they have the core curriculum and then they have electives, so always look for electives that are in highly demanding fields. For example, for H-1B, most of the cases that nowadays that I see are for data engineers, data scientists, AI. So that is where I see a lot of demand. When I see a lot of my H-1B cases, where what we are filing at a law firm, I see a lot of these BI engineers, data scientists. That is where I see a lot of focus. So definitely try to get electives done in those high demand areas because that way you can market yourself to the companies. That is very important. So good coursework. And once you're done with that, the OPT. So the OPT is the next big thing. And the big tip for OPT is start conversations with your school DSO well ahead of time. I just saw a denial today where somebody sent me a denial and said if you can fight it. And the denial was, so when you are applying for the OPT, you have very strict deadlines. So you have to apply within a certain timeline, and then you have to get an I-20 that is going to have your school DSO's recommendation, and then within 30 days of that recommendation, you have to apply for the OPT. And in this case, what happened is this young person, talked to the school DSO. He got the I-20, but then he did not apply within 30 days. He applied on 33rd day, and USCIS gave that and said, on technicality, this case has to be denied because you failed to meet the 30-day time period after your I-20 was issued. So very important tip is don't wait until the last minute. Know the rules about OPT, the initial OPT. Know when you're required to apply, the duration you're supposed to meet. Get the I-20 from your school. Be ready to apply within the time frame. Very important. If you miss the timeline, you're going to be in serious trouble with OPT. And the same thing with STEM OPT. The third thing is don't forget your STEM OPT. A lot of people who are doing STEM fields, science, technology, engineering, math, you also get additionally 2 more years. Okay, so the third tip is don't forget your STEM OPT. Again, STEM OPT again has deadlines. You do have to apply well ahead of time. You can't wait until your OPT expires. You have to get again the I-20 recommendation. You have to get the 983. So there are some requirements. So make sure you go through that and apply for STEM OPT timely. That is very important. And while you're in STEM OPT, very important thing to notice: employment, the wages. While you're in initial OPT, you can just do training. So even unpaid training is fine. But in STEM OPT, you don't have a choice. You have to get paid. So you have to find not only training, but you have to find paid work. So you have to find productive work, not just training. That is very important. A lot of people miss it. We get that RFE during H-1B. So make sure during STEM OPT you are getting paid, and know your unemployment limits. So there are unemployment limits. So the tip is, for OPT, you can have 90 days of unemployment. For the entire OPT plus STEM OPT, you can have 150 days of unemployment. So make sure you are actually looking at your unemployment days. You are figuring it out. At the time of your H-1B, they will look at your unemployment. So make sure you don't, no matter what, you don't exceed your allowed unemployment dates. This is very important. And once this is all done, you find a good sponsor, and the sponsor is applying for your H-1B. At that point of time, there is something called cap gap, and there is also something about traveling after your H-1B is filed. So make sure once your H-1B is filed to successfully transition to H-1B, you look at cap gap if it is applicable to you. If you have any travel plans, make sure you talk to your employer or to the attorney. Don't travel without telling them if your H-1B has already been filed. Very important. You have a change of status request filed and you travel, the change of status is going to get denied. So be very careful about traveling after your H-1B is filed. So I think overall, I think if you take care of these things, I think you'll have a seamless transition to H-1B, because most of the time people, I think, They are not aware of the rules. They're not aware of the deadlines. So they forget about cap gap. They forget about travel requirements. They forget about getting paid during their STEM OPT. It's not just basic training. It is more than training. It is showing productive work and getting paid. So overall, I think if they take care of all these issues, they know that these are issues and do some research, I think they will have successful transition to H-1B.
All right. Very important to keep all these rules in mind and never to miss out on dates. It's always important to make sure that the dates are correct, and not just uh, the dates that you should file, but also keeping in mind the dates of each form, because even the forms have dates issue. I mean, dates of issue, right, Chand? What about that?
Right, right. And this is another thing I see a lot of people missing. So the
Yes.
765, sometimes people, you can do online filing, but sometimes people also do paper filing. And sometimes
Yes.
they use the wrong edition. And these editions keep
Right.
changing. So people also, when they're filing their 765s, especially if they're doing the paper filing, be very, very cognizant of the edition dates. If you mess up the edition dates or you mess up the fees that you're supposed to pay, you'll get a denial. And then by the time you're able to react back, sometimes the deadlines are passed. The USS will come back and say you passed the deadline. Now you can't have an OPT approved. So very, very important. Edition dates are super important, and the deadlines are super important.
Thank you, Chand. Thank you for taking that up. Well, I will take up this next question now I have for you. Can someone on an F2 visa change their status to H-1B? Specifically, are they allowed to search for a job while on an F2 visa? And if they secure employment, can they transition to an H-1B?
Sure. So F2 visa is basically for the spouses of the students. So students are on F1. So F2 is the spouses. And a lot of times the spouses are also well qualified. They have a good degree in India, for example. They have a computer science degree from India, but they came in as spouse. And since they're
Mhm.
on their spouses, F2 spouses cannot work. So they have to stay without working. But sometimes they
Okay.
get a good job offer. And yes, the F2 person can change to H1B. It is allowed. And the way it works is they find an employer, again, just like anybody else. And that employer has to go through the lottery because they're on F2. So, uh, I mean, if they went through the lottery in the past, they don't have to go through the lottery. But if this is the first time
Mhm.
that they want to get on H1B, that employer has to go through the lottery and then apply for H1B. So just like any other regular H1B, what happens is that employer will say, this person is on F2 and we want to change their status from F2 to H1B. So you can do a change of status filing from F2 to H1B, and F2 people can search for a job, can look for a job. There is nothing wrong with that. The only thing
Mhm.
is they cannot really start the job unless the H1B is approved. So if they find a good employer, they can look for an employer. If they find an employer, that employer can sponsor their H1. And the only thing to keep in mind is wait until that H1B is approved. And once the H1B is approved, they're good to start.
All right. Thank you so much, Chand. And well, the conversation is getting really interesting, but I think it's kind of time to take a short break, but I'll quickly say hi to Sanket, Dennis. Thank you for your questions. Kavita, also, we will take up your questions for sure. Please stay with us. And also, Dennis Bang now. Thank you so much. We will take up your questions. Also, if you want to contact Attorney Chand directly, you can always write to him. It's always good to consult an expert and get your cases scrutinized, because each case is very individualistic. And so, yes, you can find the details on the screen scrolling. And definitely, to get to know more about Attorney Chand, go visit his website, spblawfirm.com. You can call him on his number, 817-523-8247. You can even mail him law@spblawfirm.com. And we'll just go for a short break now. Friends, don't go anywhere, because right after the break, we will talk more about the challenges in transitioning from F1 to H1B on Immigration and Jobs Talk Show. Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408 335 6444 or mail us at nipa@higherITpeople.com or visit our website www.higherITpeople.com. Welcome back, everyone, to Immigration and Jobs Talk Show. I am Nipasa Pradhan, and today we are discussing about what are the challenges in transitioning from an F-1 visa to H-1B visa. And it is a very critical process for many individuals navigating their career paths. So, and helping us out today is none other than Attorney Chand Parvathaneni. And it's been really good so far, so good. Chand, we've already covered much ground on this topic. And I think folks out there are also very curious because they have a lot of questions I can see. I think we should take a few of them if that's fine.
Sure. Yeah.
All right. So let's quickly take this one from Vishnu Vardhan. Hello, Chand. I need your help in my case. Thank you, Vishnu, for your questions. I'm working for MNC company in India and having H-1B I-797B approved petition, which is filed in 2022. My current employer is not sending me for stamping and travel since 1 year. I wanted to resign from my current company and do visa transfer to some other company as I have my I-797B and planning to travel United States. My concern here is will it be possible? And is there any chance to revoke my H-1B by my current employer? Or and number three is will revocation impact my transfer process and how much time will it take for employer revoking?
Sure. So the good thing is you have a H-1B approval in 2022. And what that means is you went through the lottery in 2022 and you got an approval. And that makes you cap exempt. So you are cap exempt for the purposes of H-1B. So another employer, if you have another employer who has given you a job offer, they can sponsor your H-1B and they can do a transfer. So basically, they just have to show proof that you got an approval in the past. You went through the lottery. So you do have your 2022 approval. And they can use that to file a new petition for you under cap exemption. And since this case has been approved for a long time and has not been revoked by USCIS, you are eligible for a transfer. It does not matter that this other company will revoke your H-1B. You should still be eligible for cap exemption based on the fact that you went through a lottery in the past and got an approval. So if you have a good employer who's willing to sponsor your H-1B, I think you should explore that option and you should be eligible. At least from a cap exemption perspective, you don't have to go through a lottery. You are eligible for a transfer. So, I mean, good luck in your process, and hopefully, you have a very good employer. And I don't see any problems in your case. And even if the other employer decides to revoke your case, I don't think it should impact you because you are cap exempt.
Great. All the best, Vishnu Vardhan. Sounds like it's a good scene for you. So all the very best. Let us know if you make it, all right? All right, so this next question is from Abiodun. Hello, everyone. Hello to you too, Abio. Moving on, let's take up this one from Deepika Rao. I'm currently on an F-1 visa and want to transition to H-1B. Can you explain the cap gap rules and how they impact my status?
So cap gap is, I mean, it's going to come into picture when your F1 status is about to end, but then you have a H1B filing that has been done for you. So to give an example, what happens is, for example, you go through the lottery process in March, and your H1B is picked up in the lottery. But say your OPT is expiring in the month of, say, for example, April, for example. So April, your OPT expires, so your student status is expiring, but then your H1B has been selected in the lottery. And when H1B is selected in the lottery, the earliest they can ask for approval is October 1st. So they cannot file a H1B for you before October 1st. But your student status is expiring. So in those cases, gap means there is a gap between the time your F1 status expires and the time when they can ask for your H1B. So this gap can be fixed by doing something called cap gap. So cap gap is a feature where if your H1B is filed with USCIS, if your H1B is pending with USCIS, you are allowed to stay back in the country until your H1B is approved. And depending on when your OPT card, your EAD is expiring, your employment can be extended automatically. Even if your OPT STEM OPT expires, for example, in April, and they do a H1B filing for you, uh, the time after your OPT EAD card expires, you can get extension of your employment until September 30th. So basically, they are filling up that gap because you have a H1B that is in process. So cap gap is a feature where you can extend your status even after your student status expires if you meet certain conditions, and the primary condition is you have a pending H1B.
Okay. Thank you so much. And Deepika, thank you for your question. I hope you've got your answer. Let's take up this next one. This is from Dennis. Any update on EB3 in October or prediction or possibility of direction?
Sure. And I think I'll talk about India because India is a country that is severely backlogged for EB3. So EB3 refers to the green cards. So green cards under employment third category. And October, the reason October is very special is because October is the time when the new numbers. So the fiscal year for USCIS starts on October 1st. So starting
Yes.
October 1st, USCIS will have 140,000 green cards that they can issue under employment based categories. Every year, October 1st, it gets reset and the numbers come back again. So the general consensus is October is a time when big movement is possible. And theoretically, historically, every year we see good jumps in October.
Yes.
And that being said, I think a lot of countries went back, rest of the world went back, and those people I think will again see good movement. I think it will move back up in October. But when it comes to India, India is stuck in 2012 right now. And if you see what has been happening in the last 6 7 months in the visa bulletins, India is not really moving ahead at all. It has been stuck in
Yes.
2012 for such a long time. October, I definitely think that we will see forward movement. This month, we did not see any movement at all in September bulletin. October, I think you'll definitely see some forward movement. Will it be drastic where it is like 1 2 years? Definitely not. But I think you'll see a few months of jump. Definitely, you're going to see a forward movement, a few months movement. I don't think it'll go more than a year for sure. It'll be definitely, I think my opinion is it's going to be less than a year. Probably a few months is what I think you can expect in the month of October. And then we'll have to see how the rest of the world demand is, because the rest of the world demand will predict what could happen to the India dates in the future.
Right, right, right. All right. Before we take up more from to, okay, let's take this one from Kavita. I was previously on F-1 and transitioned to H-1B, but my H-1B petition was revoked due to a company merger. Can I revert back to F-1 status, or do I need to leave the US and reapply for a new H-1B?
So, so looks like you did get your H1B approved, and if the H1B petition was revoked after October 1st, say you got your approval, and after October 1st your H1B got revoked, you are cap exempt. And what that means is you can find another employer and probably be able to do a H1B transfer. But we had some cases last year where the big companies they got an approval because you can file H1B from April, May, and June time periods, and people get an approval, but that approval is only valid from October 1st. And in your case, if this H1B was revoked before October 1st, you cannot really use that H1B for cap exemption. Only after October 1st, if your H1B is revoked, you will still be okay. You can go and look for another H1B sponsor. You can use cap exemption. So, what you would need to do and research is when exactly did your H1B get revoked? Was it after you started H1B or before your H1B October 1st date? And based on
Mhm.
that, you may or may not be eligible for cap exemption. But if you're eligible for cap exemption, you can just simply find a new employer and try to work on H1B.
All right, Kavita, all the best. And Yes, now I think let's take up this next question. This is from Nikhil. Okay, let's take this one first before Nikhil's question. Nikhil, just stay with us. This is Sanket. Can you please tell me about New Zealand visa? I do not have a job offer. Okay, that's the
I'm
question.
not much sure about countries other than US, but again, I don't know anything special about New Zealand. But Australia, so people, a lot of Indians, what happens is they go to Australia, they work, they get citizenship in Australia. So anytime somebody is a citizen of Australia, they have a
Mhm.
separate class of non-immigrant work visas called E3 visas. So if somebody is a citizen of, I mean, goes to work in Australia, becomes a citizen of Australia, they have this special feature called E3 visas, where they can use that to come to US and work in the United States. But as far as New Zealand is concerned, I'm not sure how the New Zealand rules work. But if you're working in New Zealand and want to come to US, you can definitely use H-1B, but you would need a job offer and you would need a company in US to sponsor your work visa to come to US.
All right. Thank you, Sanket, for your question. And if that was what you're looking for, I hope you got your answer. But if you have more questions, you can always keep commenting. Thank you. All right, now this next one. Yes, Nikhil on YouTube is asking, Hey Chand, I'm Nikhil. I have a master's degree in computer science and I am currently working for a DOL program called Job Corps. Do I have any chance for filing for a green card? I really appreciate.
Sure. So in the employment-based categories, typically you need a job offer for majority of the cases. So EB2, EB3, you always need a job offer. And what that means is you need to have an employer, and that employer should be filing your petition, your I-140 petition. So whoever your employer is, they would have to file your whole green card process and do the filing done. However, depending on the kind of work you're doing, if it is in the national interest, because you said it's a dual, it's a federal program, and if you can argue that your work is in the interest of the nation, there is something called EB2 NIW, National Interest Waiver. So you can
Waiver.
definitely try to explore and see if the kind of work you're doing is in the national interest, which I think potentially it could be. And then you can explore EB2 NIW. So this EB2 NIW, it's this green card filing. It's this immigrant I-140 petition where you self-sponsor yourself, but you
Mhm.
do have to prove that whatever work you're doing, it's in the interest of the nation, and that's why you need a waiver. So other people, they have to go through the process, the perm process, the labor process, where the company has to do the filing. So you would have to argue that in the interest of the nation, you qualify for that waiver, national interest waiver, EB2 NIW, and then see what USCIS does. So I think we need to look more into what your program, what your job role is, and what your qualifications are. But definitely explore EB2 NIW, because that's a feature where you can just do the sponsorship yourself without even relying on an employer.
Okay. Thank you so much, Nikhil. I hope you got your answer. And if you have more questions, we're still here for a little more time. So quickly tell us if you need more answers. All right. We also had some more questions, Chand, like from our last episode. Sorry I couldn't be here, but, the show was great and we had a lot of participation. We had questions from a few of our audience and we'll take up two today as well. So definitely we will. But quickly, we will take up right now this one from Amitabh. I am an F-1 student who completed my degree and am now on the 60-day grace period. My employer filed an H-1B petition for me, but it's still pending. If the H-1B petition is approved, but my OPT has expired, can I still travel internationally and re-enter the US on H-1B status, or do I need to wait for the H-1B approval and then leave and re-enter the US?
So again, this is a good question, and I think because travel anytime you have your H-1B in process, it's something that you really have to consider and take some legal opinion. Number one, and number two, I see that you're within the grace period, and looks like your H-1B has already been applied. So you are a classic example of cap gap. So you should talk to your school, and you might be eligible for cap gap, because looks like your H-1B has been filed before your OPT expired, and then you're also within the grace period. So anytime your H-1B is applied before your grace period, you should be able to stay back in the country till your H-1B is adjudicated. And if your H-1B has been filed before your OPT has been expired, what happens is you get an automatic extension of your OPT till September 30th. So
Hmm.
you might even be able to work. So go to your school DSO, show them proof that your H-1B has been filed, show them the receipt, and talk to them about cap gap and see if you are a candidate for cap gap. And normally they look at the rules, they will see when your H-1B has been applied, and then they will see when your grace period has started, when your OPT has expired, and they will
Hmm.
tell you if you're eligible for cap gap. So definitely talk to your school about cap gap. You might be eligible. They might be able to issue a new I-20 as
Hmm.
one thing. And the other thing is, say for personal reasons you want to go out of the country, if you travel out of the country. If you do travel out of the country and your H-1B was filed with change of status, what will happen is your H-1B can still be approved, but your change of status, that will be denied. And what that means to you for from a practical standpoint is you have to wait outside until you get your H-1B approval. Once you get your H-1B approval, you go for stamping, and then you get a H-1B visa, and then you enter back into the country. So talk to your school DSO. If you're eligible for cap gap, take cap gap and stay back in the country. But if you have to depart from the country, just understand that you would have to wait until you get visa stamping done and come back. Okay. So either way, I think your H-1B should not be impacted. Uh, if you're eligible for cap gap, you can basically, even after your grace period, you can stay back in the country. If you're not eligible for cap gap and your school refuses to give you an I-20, travel out of the country, be prepared to go for stamping, and then come back into the country.
Okay. All right. All the best, Amitabh. Thank you for your question. And now, Chand, let's. I was telling you about the questions from our last show, so let's take up this one. This is from Mr. 2603198 5. What is prediction for EB1 India in October 2024?
So EB1 right now in September bulletin, if you see, the date has moved back to November. So it is November 2022, and last couple of months EB1 has also been pretty bad. Sorry, India is sorry February. China is November. India is February 2022. And what that means is anybody in EB1 category before February 2022 can get a green card now. So after February 2022, even if you have an I-140 approved with EB1, you cannot get a green card. So more than 2 years plus of wait time. What will happen in October? I definitely think the dates will move up because October EB1 typically moves a little bit faster. EB2, EB3, I don't think India will move that drastically, but EB1, I definitely think you can probably see at least a couple of months to close to a year. Uh, there is a good possibility. I mean, my guess is probably at least a year is what I assume, because right now you are looking at more than two years plus backlog because the priority date is stuck in February 2022. So definitely, my guess is you can expect close to a year. And that being said, what I always do is look at the second chart, the date of filing chart. And in September bulletin, the date of filing chart is not that attractive. If you look at the chart one and chart two, they're very close. Both are in February 2022. So it some people interpret that as saying that hey, the dates might not move very far ahead because even the second chart is pretty backlogged. But because it is October, because we know that another 40,000 green cards can be given under EB1 category. So it is 40,000 for EB1, and out of which 7% is for India. So which means that there is still a good potential. And I would say a couple of months to a year is probably what we can expect in October for EB1 India.
Still, some movement is still better than nothing. So I think that'll still be good. Thank you so much, Chand, for the prediction, and let's hope for the best. Okay, now this next one, yes, this is also from our. This is from G1 F1. So the question is, how about countries that have not been oversubscribed? Would the retrogression still affect them? I think this retrogression is supposed to be by country. Those that have been oversubscribed should be listed, and those that have no should also be listed so that we can know what expectations we are to have from our embassy.
Sure. So, I mean, again, in September bulletin, it was kind of shocking because EB3, which is rest of the world, EB3 for rest of the world we saw like the dates go back. They went back almost to 2020.
Mhm.
And EB3, rest of the world, is typically not that backlogged, but it did go back. It was heavily retrogressed back to 2020. But my guess is rest of the world will definitely come back up in October. Rest of the world typically doesn't see that kind of huge backlog. So retrogression, I think, is still going to impact countries like India, China, the oversubscribed countries, but not really rest of the world. Rest of the world, I do think that you will see some forward jump in October. Probably a good jump in October.
Good jump. All right. Thank you for your question, G1. I hope you got your answer. And thank you, Chand. All right. So let's move on now quickly back to our audiences right now who are looking for more questions. And Nikhil, by the way, whose question we took up earlier, says thanks also. So thank you, Nikhil, for your question as well. Now let's take up Sakshi. As a consultant working on F-1 OPT, I have been assigned to a client project at a third party worksite. My employer filed an H-1B petition for me, but the petition lists my employer's office address, not the client site where I'll be working. If the H-1B petition is approved, will I need an H-1B amendment or a new labor condition application, LCA, to work at the client site? And another question is, and what documentation will be required to ensure compliance with USCIS regulations and DOL requirements?
Sure. So for everybody out here who has an H-1B filing in process or about to be done, remember your rights. Your right is that LCA copy has to be given to you. So every employer has to give the copy of the LCA underlying your H-1B filing to you. It's not an option for the employers. They have to give it to you. So make sure you do have the copy of the LCA in your hand. Take a look at the LCA. LCA will have something called the worksite address. So look at the LCA, look at the worksite address. Once the H-1B is approved, you can only work as per the terms of this LCA. So if the LCA says you're supposed to work at so and so location, you have to work at that location. Or at least you have to be within the commutable distance, at least in the same metropolitan statistical area, the same metro area of that LCA. So if your company has a H-1B filing done for you to work as a software developer, say for example in client Verizon in Dallas area as a software developer, and tomorrow your project can change. But if you're again working in Dallas area, maybe for another client, but still in the same occupation, you don't really require an amendment. So the bottom line is take a look at your LCA, look at the worksite address. And in your case, if your employer is putting the right location, you're good. But tomorrow, if your employer says, no, you have to work at a different location, which is not in the same metro area. Suppose if it's Dallas, a different project in Dallas area is okay. But if they say, no, you have to work in Austin at our headquarters, for example, you have to have an amendment filing done. Without an amendment filing done, you cannot just relocate. So the crux is you can only work from that city where or that metro area where you're allowed to work. Use the LCA to determine whether you're working at the right location or not. If not, you're not in compliance. You're not in compliance with the H-1B regulations unless an amendment is filed. So always a good idea for all of you to take a look at your LCA. If there's any discrepancy, bring it to the employer. Say, hey, the rules say that an amendment is required. Okay, and document it. Okay, so that way, if they accidentally overlooked something, you can make sure that you did uh, point it out to them and got the filing done. And if not in compliance with the LCA, you're gonna have trouble when you go for stamping down the line, maybe at a USA site visit and so on. So it's good at least you notice this discrepancy. So just check with your employer and see what happened, and maybe they have a different project in mind from October. So check with them and make sure you are working only at the locations as stated in your LCA.
Very important. Thank you so much, Chand, for taking that up for Sakshi. And Sakshi, thank you for your question as well. Let's move on now to this next question. This is from Jagadish Kumar. Hey Chand, I'm Jagdish. Any update on pilot project? What is a pilot project and
I
where
think
have you
it's
taken?
yeah, I think the only pilot project I was aware is earlier this year they had a pilot project for H-1B visas. So basically, stateside H-1B visas where people don't really have to go to India to get stamping. So it was a pilot project where they said they will only let some people get H-1Bs stateside, basically within US, without traveling out of the country. And they're going to use the data from that project to kind of open it up to more wider audience. And I've seen this in January, I mean February. Initially, a lot of people were successful. Whoever were allowed to apply, they were successful
Mhm.
because they had some criteria. They said only if you meet this certain criteria, you can apply, you can be a part of that pilot project. And the way I saw it was the pilot project was definitely successful because I did see a lot of people get the H-1B visas in that pilot project, where it's a pilot test run where they're trying to
Mhm.
see how it works. But now we are in the middle of an election year. We are in the middle of an administration change. So I don't know I mean, whether they will make or open up that pilot project, make it more wider, and let everybody use that process where they can get H-1B visa while they're in US without traveling to India. So we don't have more news about it in the recent times, but they have data. So I think it was a successful pilot test run, and we have to see because they will also look at their administrative burden and what kind of challenges they had on the administrative side. And I think down the line we will know whether it's going to be opened up for more people or whether they will shut it down. At this point of time, we don't know what's going to happen. Definitely, the administration will change after the elections. So I think a lot will depend on the priorities of the new government, new administration, new president.
Definitely, definitely. And I mean, come November, we are definitely going to have a lot more changes. But before that, we also have October, which is going to be a new fiscal year for us. And I think we are all looking forward for big changes this October. And let's take up the last question for today, Chand. And this is from RK on YouTube asking, how do you think high NIW approvals have impacted EB2 row? They historically haven't been backlog, and we see that the category has been backlog over the past 2 years, which previously never happened.
Sure. I think definitely high NIW approvals will impact EB to rest of the world also to some extent. The reason is there is a fixed limit. USCIS cannot exceed the 40,000 EB2 green cards. So under EB2, we again have 40,000 green cards. 7% can come to each country. And when we have NIWs, so what happens is we have NIWs, so we have other countries. So some people probably have priority dates well in the past. So the demand, as we are seeing more NIW approvals, it means that there is more demand on the EB2 side. And
Mhm.
again, NIWs can be from different countries, but always you have more approvals, which means more demand. And whenever there is more demand, EB2 or ROW is going to get impacted because DOS, Department of State, USCIS, they're indicating that they are seeing demand from rest of the world. So more approvals, more people getting into the system is going to impact the priority dates because there is only 40,000 green cards that can be issued under EB2, and there is not much spillover. This current year, from their disclosure, they're saying that only they had about 20,000 spillover from the other categories. So 140,000 is set in law. So no matter what, 140,000 is allowed to be given for all the employment-based categories. On top of it, they had 20,000 extra green cards, so they had 160,000 green cards. There was not a lot of spillover. So not having a lot of spillover like they had in the previous years, I think also impacted rest of the world. That was one reason, and definitely I think a lot of demand. And when you say a lot of EB2 NIW approvals, it definitely means that there is a lot of demand from everywhere.
Yes. Definitely, definitely. RK, thank you for your question. Really good to have you participate as well. And Chand, also very enthusiastically, you answered so many questions from the audience today and also our questions. Thank you so much, Chand, for today.
Thank you, Nipasa.
But I think, there's a lot more to talk about this topic. And I think we should surely continue with this topic in the coming week also, if possible. But also, before we leave,
Sure.
Chand, if you give our audience an end note just to wrap up this discussion for today.
Sure. And I think a lot of audience today are probably students because students transition are trying to transition to H-1B. I think this was a great platform because I think because of your platform, I think we're making people aware of the kind of arrests that are happening. So we
Yes.
want people to be aware. I mean, the reason I think we need to bring up these kind of things is not to shame some people who have done the crime. It's That's not the goal at all. The goal is to show that, hey, look, a small crime could totally jeopardize your career. So that awareness has to be raised in the society. And I think it's times like these where you go back and reflect and say, hey, the small people think it's a small thing, a small crime, but now their entire career is jeopardized. So definitely, I think it's a message to everybody out there to follow the law 100%. It's not like you follow the law 99% of the time and 1% make a small mistake. No, it's like 0% mistakes, especially when somebody's an immigrant coming to US. The burden is even more to make sure that there is 100% compliance, and that's the goal. And I think the forums like this, like talk shows like this, I think it's an opportunity for everybody to kind of regroup and say, hey, this is very important, and you can never ever forget the importance of following the law.
So true, Chand, and thank you so much for encouraging us with your words as well. We will keep doing our thing. We love doing this. So, friends, you too, don't forget to love us. Just show your love by liking, sharing, commenting, and definitely participating as well. So, thank you so much once again, Chand, for doing this, and I hope to see you again in the coming week.
Yeah, thank you, Nipasa.
Thank you, thank you. And folks out there, thank you so much. It's been lovely having you once again. So don't forget to contact Attorney Chand. His details are on the screen. You can call him at 817-523-8247. You can mail him at law@spblawfirm.com and go visit spblawfirm.com to get to know more about Chand and SPB Law Firm, definitely. So thank you once again. And it's always best to consult an attorney because every case is different. So you might as well. Also, if you're looking for project placement, career opportunities, for maybe looking for sponsorship for H-1B, E3, OPT, TN, visas, anything about immigration at all, you can definitely contact me as well. My details are on the screen. My phone number is 408-335-6444, and that's where you can even WhatsApp me. You can even email me, nipa@higherightpeople.com, and definitely to get to know more about us, go check us out at www.higherightpeople.com. Thank you so much, friends, and this is Nipasa Pradhan signing off for now, but don't forget to subscribe to Immigration and Jobs Talk Show. Bye-bye. Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higherightpeople.com or visit